He's not here right now. He's not here. I have a bill. Can I turn the gavel over to just anybody? He would be. He would be the same. Okay. Okay. No, I'm trusting Teresa, my clerk, who said that is the next in line, the senior guy. Yeah, it would be the senior guy. This is not good. They got confidence in you. I want you to do good on my bill. All right. Clerk called a roll. Here. Thank you, Teresa. If Representative Estes up in prayer, we'll get started.
Father, we thank you for the gift of this day. We thank you for the opportunity to serve the people of this state. I know, Lord, that many important issues come before each committee, and I just pray, Lord God, that you will help us be mindful that we represent all 5 million people who live in Alabama and call it home, and just pray, Lord, you'll give us your wisdom and courage to make the best decisions on their behalf. Forgive us where we've sinned against you, Father. In Christ's name we ask it. Amen.
All right, that's going to bring us to our first bill, House Bill 320, Representative Bedsole. And he just walked in the room. There we go. You're up at the podium.
You're going to warm the crowd up first or something. So, all right. Thank you, Mr. Chair. Just got here from another committee meeting, so sorry I'm running a little bit behind. Oh, so this bill that I have before you is HB 320. Back in the session in 2021, we passed a bill to do some protections for our juvenile offenders who committed a crime and charged an adult. That particular law in 2021 that we passed prohibited law enforcement and any media outlets from releasing the name or image of a juvenile who had been charged as an adult. And there was some vague references to a process that at some point when the court system conferred or validated that the charges were accurate on the individual, that law enforcement and other media sources could release it. But it wasn't very clear. So this is a little bit of a cleanup because we've had some rise in juvenile crimes committed, crimes that are of an adult nature and charged as an adult. This bill will specifically lay out provisions in which that a juvenile, when they're charged as an adult, that law enforcement has the ability to release the name and photograph of the juvenile. The citizens in our communities where these crimes are occurring are saying, why can't we know who the person was that was charged with this crime? So specifically, it lays out that when a hearing has been held pursuant to Code 1513-3, there's been a probable cause determination by the district court. An indictment has been issued by a grand jury. Those are two ways in which time these things occur, law enforcement then is okay to release that information. Also, one other thing this bill does was, because our adult systems in our jails, they're very accustomed to operating with adult offenders. A lot of our systems are automated. So when someone comes in the facility, it recognizes they're adult. It will publish their information to maybe a website or things of that nature. There's some unique circumstances in which someone could have been a juvenile when charged, yet when they get arrested, they're an adult age. So the previous bill, even if a law enforcement unknowingly, accidentally released that information, could be charged criminally. Were you going to charge the IT director? Were you going to charge, who were you going to charge in that case? So what we want to do is get to the spirit and intent of the original bill. So if law enforcement knowingly discloses that information, so a jail official, a law enforcement person calls the media to give them an inside tip, well, that's a criminal offense. Otherwise, if it's an accidental release of information due to some automated procedure, there's nobody there that's going to be held criminally punishable. So with that, Mr. Chairman, I'll be happy to answer questions.
Any questions from members of the committee? Representative Wadsworth?
I do. One of the questions in here is that you have to have a probable cause determination by the district court. There are some district courts that will actually say in court that I've never found no probable cause, which basically means that in every single case when a juvenile is charged, it can be disclosed.
So the reason that language is there is because there are some laws by statute that is an automatic adjudication. So if a juvenile commits any list of those offenses, it's automatically adjudicated to the adult system, which really goes to the spirit and intent, the reason this law was originally created. Because if a law enforcement agency sort of overcharged a juvenile, it might become an automatic adjudication, and they've lost those safeguards. So what this bill aimed to do to begin with is to have that extra step to ensure that they weren't overcharged. And if they had been charged at a lesser crime, then their name and information may have not been made public, and the damage is done at that point.
But in a county where the court is automatically finds probable cause, that means that every single case, no matter what, whether or not they've been indicted or whether or not the grand jury's done anything else, it's going to be disclosed.
So I think there's a couple pieces of the procedure. There has to be first probable cause to obtain the warrant. So that's kind of step number one. And the magistrate is typically the person that determines probable cause. The next step that this bill ensures is that there's a probable cause been obtained for the warrant, but then beyond that, there has to be a preliminary hearing for the judge to then weigh in to determine if there was enough.
But in a lot of cases, the court automatically finds probable cause no matter what.
So yeah, and I don't know specifically. I can tell you any of the court systems I operate in that the judge has to weigh in on it, and so that's the next step of sort of protection of that juvenile is the judge has to weigh in and say yes, in fact, there is probable cause.
He would have to find no probable cause for it not to be disclosed.
That is correct, because at that point, that's his acknowledgement that the case can continue on as charged and that the legal proceedings are true at that point. They're still on track. We're not off track in terms of the correct charge for that individual.
Would it not be better to make it where when an indictment has been issued, as opposed to the probable cause part?
I don't think in all cases that it goes through the grand jury process. Some of the cases don't, and that may not be the case in every county. But either way, you've had a second set of eyes to lay on the facts. It's not just a singular magistrate. There's either the judge in the process after hearing the evidence from both the defense and the prosecution, or you have the grand jury set up where you have 18 individuals that are called and all the evidence is presented.
Well, that's my concern is if you have probable cause in every single case, then you might as well just say they can disclose everything.
Yeah.
Any other questions from members of the committee? If not, I'll entertain a motion for favorable report. Motion for favorable report by Representative Pettis. All in favor indicate by saying aye. Aye. All opposed. The bill has a favorable report.
Thank you, Mr. Chairman.
I'm going to skip over 332, and I'll bring it up in a minute. So that brings us to House Bill 347, Representative Bolton.
Thank you, Mr. Chairman, committee. In our earlier work to modify Code Section 12-1256 regarding the disposition of records after issuing a uniform traffic citation, I noted that there was an issue here that was a concern to us regarding the potential that the issuing officer for a citation could potentially be held in contempt for attempting to do anything with that citation before the court. Just wording. All this does is just adds a section to, a sentence to Section B of this bill, this law. And what it does, it just adds a sentence that says, other than the issuing law enforcement officer. And what that does is originally the way the law reads is that if anyone goes, solicits or aids in the disposition or attempted disposition of a uniform traffic ticket, they could be held in contempt But the bottom line is, I think that was a confusion when they wrote the law, because anytime that the issuing officer would be the complainant in this situation, and the complainant can always dismiss a charge before the court without fear of any kind of litigation or anything like that. I just felt like we needed to specify that, because without going into long depth, there were many times over the years in my 25 years of law enforcement work that I would issue a citation, say, for reckless driving to a young person, and then a parent would approach me because the child was having problems. And what we would do, we would go back and get some probation or something on that citation and try to correct that problem before the child got in any other kind of problems. And I want to just make sure that that's very clear that the officer can do that.
Yep. Any questions by members of the committee? Not seeing none, I entertain a favorable motion for, motion for favorable report. Representative Fiddler, all in favor indicate by saying aye. Aye. All opposed? Okay, Bill has a favorable report.
Thank you.
Since we're talking about tickets, we're going to move to House Bill 332. It's my bill, so I'm going to turn the gavel over to Representative Pettis.
Mr. Chairman, you present your bill.
All right, so what this bill does, real simple, is it allows to use current technology to swear on tickets, parking tickets, and state citations. If you remember last year, we passed a law on the retail theft side where we can remotely swear to shoplifting and things like that. So this will, in the case of Birmingham, I can speak to Birmingham. The magistrate's only on duty 12 hours, but they are on call the other 12. And the overtime that the city's paying for officers that are fixing to get off work, they have 48 hours to swear on tickets. So if they're going on vacation or something like that, it creates issues there, not to mention it's going to save a lot of overtime for the municipalities out here. So all this does is allow you to remotely swear to tickets and certain misdemeanors.
Any questions? Go ahead.
When you say certain misdemeanors, because I just see citations, what do you actually mean?
All right, so currently in current law, there's things like public lewdness or things like that where an officer would normally give a summons on the scene and not make a custodial arrest. Then they would be able to swear to that ticket remotely also, or that non-custodial arrest.
Any other questions? Anybody have a motion? Have a motion for, have a second?
Second.
Okay. All in favor, say aye. Bill has a favorable report.
Opposed?
No opposed?
Thank you. Appreciate you. All right. Is Representative Faulkner here? Is anybody carrying his bill, or are we going to wait? We'll put him to the end then. All right, that brings us to House Bill 375, Representative Shaver.
Thank you, Mr. Chairman. There is a sub-bill that everyone should have a copy. Currently, under Alabama law, to operate a vessel on the waters of this state, an operator has to pass a boater safety certification unless they are renting a vessel. There's a procedure in place where they watch a safety video and the person renting the vessel certifies that they've had that safety instruction. Unless somebody is from out of state, they under our law, they can come into this state and operate a vessel up to 45 days in a calendar year without any kind of boater certification whatsoever. So we're actually requiring Alabama residents to do something that we don't require from out-of-state visitors. This would require a boater safety certification. If that person has a vessel license or that certification from their state, that we would reciprocate and acknowledge that. And if they do not and come to this state and want to operate a vessel, then they can actually go online and take our boater certification course, which prints out a certificate at the end to show that, you know, they have had that, that instruction. So that's what this bill does. It doesn't change anything about the rental laws except to operate a rental vessel, an individual would need to be 16 years of age. Any questions from the members?
I move for favorable report.
Seeing no questions from committee members, so we got a motion by Representative Bolton for favorable report. We got a, I'm sorry, we do have a sub. You have
Yes. Well, there were some suggestions by Leah and Department of Conservation on the difference is, let me find where. From Conservation about the rental vessels, they have rental boats at state locations, and that they are not registered with Leah, but that it leaves them out of that. But just some clarity about the underage operators to make sure that those out-of-state operators are following the same rules, because in Alabama, someone who's at least 12 years of age and less than 14 years of age that's passed a boater safety certification can operate with a person who's age 21 or older that's also certified. So they just add in some language there to make sure that those operators are held to the same standard as state residents, and then the 16-year-old to operate a rental vessel.
Sub. Is there any questions on the sub by any members of the committee? If not, I'll entertain a motion to adopt the sub. Motion to adopt the sub by Representative Estes. All in favor indicate by saying aye. Aye. All right, now the sub is before us. If there's no other questions, I entertain a motion to adopt it. Motion to adopt sub by Representative Estes. All in favor indicate by saying aye. Aye. All right, bill has a favorable report.
Thank you, Chairman, members of the committee.
As substituted. All right, we're going to go back to House Bill 362 by Representative Faulkner. Representative Pettis is going to carry the bill.
Members, what this bill does, it just says municipality that once they convict somebody of DUI, they have to report the findings to ALEA within 5 days. If it's not reported, they have to forfeit any fees or costs they collect. That's basically what it does.
Any questions by any members of the committee? A question by Representative Wadsworth.
I guess I'll turn around this way, but as far as the time period to file an appeal from a municipal court is how many days?
14, isn't it?
It's 14 days.
Yeah.
So therefore, if this case is appealed, they have a municipal conviction, and it's appealed to the circuit court.
There won't be a final conviction until
Well,
they have to make notice. Usually,
let me just say this.
Go ahead.
I think the municipality has to then turn around, they forfeit the fees, and then they have to then turn around and send notice to the state of that in 5 days, otherwise they lose their fees.
let me change that. It says 5 but it says 60. Any municipal court that fails to submit the data required in this article within 60 days.
But
It's not the 5, it's 60 instead of 5.
But it's 5 days. It's 5 days. They have to submit it within 5 days.
What line are you looking at, Pettis?
I'm just looking where they highlighted. It says, under 12-14-113, any municipal court that fails to submit the data required in this article within 60 days of the due date, or for driving under the influence convictions as required in section 12-14-115. So it's 60 days. I don't know where the
60.
5 days come
Where'd
in.
that come from? I don't see that.
5 is in the first part, in the synopsis, but in the bill it says 60 days.
On page 60, line 61.
Yeah, it says 60 days.
Line 61 says 5 days.
Okay, so it's 60.
Oh, okay.
And then the problem you're going to run into is that municipal courts are going to send this conviction in because it's within that 14-day period. He gets appealed, and then the person who has the ticket, their license are going to be suspended to get their, even though they're on appeal, and then it's going to be, then they'll have to pay $350 to get reinstated on that. That's an issue because, if you don't,
Should be I think it should be 60 instead of the 5.
well, this says 5.
Yeah, it says over here, I just looked at the underlying
Yeah.
part, what they changed.
That's in the synopsis. In
Yeah.
the law, it's actually 60 days.
Well, in the very, very bottom of it, on section 2, it says, all municipal courts shall report within 5 days.
Line 60 and 61.
Yep, over here it does. They didn't highlight that part.
And, I'm gonna make a motion to send it to a subcommittee where we can address that. And there's other issues too. We've got municipalities that don't have the number of people available to handle these and get everything submitted in a timely manner, like some larger areas. And, we can correct it, but we just need to, I think we need to kind of look at it in a subcommittee, from a subcommittee. And I'll make a motion to send
Okay.
it to subcommittee.
You hold your motion while I ask a question? You hold your motion for a minute? So go back to that 5 days. Where'd you see it again? Somebody said it's
Over on the third page. On page line 60.
960.
So they didn't highlight that part.
Yeah, it does that. Why don't I just carry it over and let the sponsor work on the bill and bring it back up? All right? I'm going to motion to carry the bill over. Motion by Fiddler to carry the bill over. All in favor say aye.
Aye.
Bill's carried over at the call of the chair. All right. We'll get that addressed and bring it back up. All right, that's going to bring us to House Bill 376. We do have a public hearing. We have 3 folks have signed up that oppose the bill. We're going to give 3 minutes, if you would. I don't know. Well, I'll call your names. Try not to be repetitive, and we'll give you an opportunity to address the bill. I do believe there's 2 amendments. Is that correct? The sponsor bill has 2 amendments. So if you'll go ahead and explain your bill, we'll get the amendments up before us. We'll adopt the amendments, so we'll have the bill the way it needs before we have the public hearing. House Bill 376, Representative Yarbrough.
Thank you, Mr. Chairman, members of the committee, for your time this morning. House Bill 376, the Lake and Riley Act, was inspired by similar legislation that was recently passed in Georgia. Lake and Riley was a nursing student in Georgia who was abducted and murdered by an illegal alien while jogging at the University of Georgia in Athens, Georgia. Our nation's security and the lives of our people are at great risk because our federal government has largely abandoned their sworn duty to uphold and defend in regards to the southern border. And obviously nobody here needs to be told the condition of that. And in fact, we heard yesterday how much of our National Guard in Alabama has been sent to help along the southern border in regards to what amounts to, by all accounts, close to an invasion. In fact, just recently, the Mexican president, known as AMLO, has threatened to keep and increase illegal immigration across our southern border unless we give in to his political demands. Our federal government could prevent all this immediately if they would enforce the law and do their job. And so House Bill 376 empowers local law enforcement to participate in the enforcement of immigration laws in connection with the federal government in a way that will hopefully prevent another Lake and Riley situation from ever happening, and also help give a more formal structure to the detaining, tracking, and transmitting of illegal aliens to the proper authorities so that the documented transparency is in place for local law enforcement to also help highlight the severity of the issues, bring pressure to the federal government to do their job with us faithfully, and have another tool to help serve and protect our communities. I do have a couple of things to share with you this morning. One is from Sheriff Eric Ballantyne from Colbert County. He said, "I have reviewed the bill that Representative Yarbrough is presenting. I'm in support of this bill." He wished he could be here this morning, but Leighton was hit with some straight line winds and tornadic weather yesterday. It is imperative that we protect our citizens from the detriment of these illegal immigrants. We must put into place law that will allow us a course of action, and this bill will help save lives. I have another text message this morning from the Chief of Police in Trinity, Alabama. He said, "Locally, it is very difficult to locate an illegal alien if a warrant is issued due to a crime committed. This bill would assist in sending, receiving, and maintaining information on illegal individuals locally. Current local law enforcement cannot enforce federal immigration laws, and this bill would allow local agencies to enter into MOUs with federal agencies to enforce current laws and receive federal assistance based on MOUs." He said, "Currently, jail staff is not reporting the status of illegal aliens, but this bill would require the jail staff to do so. And obviously, this is an issue that is detrimental to our communities, and we must begin to take action." And then I have another message this morning from the Sheriff of Chilton County, John Sharon. But for the sake of time, what I'd like to do, obviously, you have the bill before you there, and you can see how that, the basic idea behind the bill is that it allows local law enforcement to participate in the enforcement of federal immigration laws for the purpose up to 48 hours of determining should an individual be here illegally. Obviously, there's not resources to arrest and detain every illegal alien that's in our country, but we have to trust our law enforcement to have the discretion that they need and their job role to help prevent terrible crimes from happening. And that's the idea behind the bill, is that it gives them more structure to be able to do so. I do have a very short, he couldn't be here this morning, and I'll close with this. But this gentleman who was recently in election for sheriff for Jefferson County, I wanted to play this here for you, but I've got my microphone so I can just play it here. It's a really short video here. He wishes he could be here, but he's involved in ops and rescuing some young people and children from human trafficking. This is what he wanted me to share with you this morning.
Hey guys, my name is Jared Hudson. I'm the CEO of Covenant Rescue Group, nonprofit that deals with human trafficking, in particular through child exploitation. I'm also a law enforcement officer in the state of Alabama and a federal task force officer in the state of Alabama. Lastly, I'm a former special operations guy. I was a SEAL, and I currently work as a contractor on overseas jobs regularly, as we speak, to help our nation fight those who are fighting us. It's through these lenses, or through these titles, that I look at House Bill 376 and why I believe House Bill 376 is vitally important. House Bill 376 is going to give local law enforcement the ability to target individuals who are here illegally, but that are targeting us. This is not going to give them the ability to go after individuals that aren't doing anything or don't have any nefarious intent. And that's important to me. One, as the CEO of Covenant Rescue Group. We work with local law enforcement agencies in Alabama this year, made 26 felony arrests for people who are showing up to have sex with children or sell children for sex. We've done this from as far north Alabama as you can go to as far south Alabama as you can go. And over those 26 arrests, we've averaged 2 illegal immigrants per operation. So that's 6 total. 6 ICE holds per operation. And by ICE, I mean Immigration, Customs, and Enforcement. We have these ICE holds come in, and these individuals have no way of being targeted previously, but they're showing up to buy a child or showing up to sell a child, whatever the operation called for. House Bill 376 would help target those individuals before they even get to the point of being able to buy or sell a child. As a law enforcement officer, I don't just see the human trafficking side of it, but I also see the nefarious intent of it as we serve warrants, as we go out and we do work around the community or across the state of Alabama. It's not just human trafficking, but it's any nefarious intent. Those individuals who are here to break our laws, and we have no ability to target those individuals because we don't know who they are oftentimes. Again, because they're illegal immigrants. They're here illegally. And finally, as a former SEAL, as a current contractor, still doing special operations stuff all over this nation, we see what's going on in Haiti right now. I've got quite a few buddies in Haiti as we speak working. One of the things that we see is as people are pouring across this border, we are opened up for the risk of terrorist threats here on U.S. soil. So these are individuals who I've seen that hate not only us, they hate our way of life, they hate our family. They can't stand the United States of America. They can't stand people in Alabama. And the open border is a risk for us, so illegal immigration that goes unchecked or untouched creates an even greater risk. And so as a former special operations guy, I really view House Bill 376 as a way to start mitigating that risk. So through those 3 lenses, one is the CEO of a human trafficking organization, 2 is a law enforcement officer, both state and federal, and 3 is a special operations guy. I think House Bill 376 is at least a way of starting to mitigate the risk and issues that we see with illegal immigration, in particular those individuals who are showing up to break our laws, to target us, to target our kids, or to terrorize us by trying to take away not just our lives, but our way of life. So I encourage you to support House Bill 376. I believe it's a good bill, and I believe it will help the state of Alabama across the board in this fight against open borders and illegal immigration.
All right, if you would, go ahead and let's address these amendments, get the bill
Sure thing.
amended before we move on.
Yep, so I've got a copy of one of the amendments here. I think the other one was handed to you, I believe. But
Start on the one on page 5.
okay, I actually was not given a copy of that amendment.
Okay,
I'll
Representative
do the
Pettis is
Okay.
going to handle
Okay.
amendments.
Go
for
ahead.
you.
Okay.
Go ahead.
Right.
Go ahead, Representative Pettis.
Amendment 1 says replace line 172 through 173 on page 7 with the following. Employee shall have immunity from any damages or liability subject to section 36(1)(12) when he or she acts to enforce immigration laws.
Yes, it's a favorable amendment.
Any questions on the amendment? If not, I'll entertain a favorable report. A motion to adopt the amendment.
So moved.
I got a motion to adopt the amendment. Representative Pettis, all in favor indicate by saying aye.
Aye.
All opposed? Okay, the ayes have it. And we have one more amendment.
Second amendment says replace line 131 through 132 on page 5 with the following. Local law enforcement agencies' employees shall send, receive, and maintain.
All right. Any questions on the amendment? If not, I entertain a motion to adopt the amendment. Moved by Representative Stringer. All in favor of adopting the amendment indicate by saying aye.
Aye.
All opposed? Okay, now the bill is before us amended. We have a question by Representative Morris.
So I just want to ask, I kept hearing the person that you did with the recording, they kept saying targeting.
Yes, ma'am.
So targeting basically like profiling. They are all the same thing. So are you all going to give like local law enforcement the rights to, as soon as they see someone who may fit the description, because we know what fit the description actually look like. I'm speaking as right now as a young black female.
Yes, ma'am.
So I want to know, what does profiling and targeting look like for your bill when you're actually seeing someone out? How do you come up with the sense of knowing who are illegal aliens?
Well, I would assume that in the normal course of law enforcement, the police who are on the grounds each and every day, they're witnessing, they're seeing, they're observing. No doubt things are being reported. For example, Sheriff Valentine in Colbert County has stacks of complaints of violations of noise ordinances, of citizens calling in suspicious behavior. So, there's obviously in the realm of police work, when you're dealing with people who are here potentially illegally, there's in the natural flow of their job as police, they're going to have to use their sense and discretion to know if something seems wrong.
We're gonna have the police to use their sense and discretion when it comes down to profiling. Do you understand how that sounds? To a group of people who have already been profiled from day one, we're gonna use the same people who were put in place to profile. That just does not make any logical sense. We're gonna use a system that was created, because we're gonna just actually sit and act like we don't even understand the history of what's been taking place over the years concerning black and brown. And then we come in and we just put things in place and act like, or say, on another hand, we should just forget about it, but then we keep bringing things like this. That's gonna be profiling people for just being here who probably was already here based on history.
Well, this problem that we face is not a problem that we created. It's a problem of a failure of leadership in our country. And so this is a situation that local law enforcement didn't go looking for, but it's been thrust upon them. And in order to protect their local citizens, to serve and protect, this is a reality that communities across our state are facing. And so this isn't a situation that we went looking for. It's been brought to us. And
Okay, so what other countries border the United States?
Well, obviously there's Canada and Mexico.
Okay, so you got Canada and Mexico, but we don't have no issues with Canada border. We just got issues with Mexico border.
Well, we certainly
and we got issues with Haitians. Just look how it sound. You got black and brown, we got a problem. But on the other hand, we don't have a problem.
Well, there's only one president.
I'll be done.
Hold on.
I'm gonna let him
hold
go.
on. Let
I'm
her
finished.
ask you a question and then give her an opportunity to ask it.
I'm finished.
All right.
I'll
Hold on.
respond.
Hold on.
Okay, go ahead.
Well, here's what we're going to do.
Okay.
I've got some other questions by members of the committee.
Sure.
They're going to ask them, answer the questions. We're going to go into the public hearing because there may be more questions by members of the committee for individuals that want to speak here today. So what we can do, go into the public hearing, and then you can ask questions of the speakers, or you can ask questions of the sponsor of the bill. Representative Estes, since you were next, go ahead and ask your question, and we're going to go into the public hearing.
Thank you, Mr. Chairman. With all due respect to my friend and colleague, I think there is a difference between the Mexican and the Canadian border because that border is not being used to our north to open the gateway to not just Mexico, but all of Central America and South America that they don't have the same geographic connections to our borders on the northern end of this country. Let me just clarify with the sponsor of the bill. We are not creating any new laws to protect ourselves against illegal immigration. All you're attempting to do is create a partnership between the federal government with local law enforcement agencies to enforce existing laws.
That's right.
Because we simply do not have enough federal agents to tackle this problem that is about to overwhelm this country. So all you're doing is allowing for partnerships to allow county sheriffs and municipalities to enter agreements with the federal government to enforce existing laws.
That's correct.
Thank you.
All right. Now we'll go ahead and what we'll do, we'll start the public hearing. We'll have 3 minutes. We have 3 individuals that want to speak unopposed, and 3 minutes per speaker. Teresa will keep the clock. About 10 seconds towards the end, she will let you know. So wrap up your thought, please. And with that, our first speaker, and forgive me on the, I cannot understand the spelling on this last name, but Anna. Is Anna here? Okay, Anna, you have 3 minutes.
Good morning, committee members.
State your name for the committee.
Anna Ockert, Ockert. Today I bring forth a matter of utmost importance that calls for our collective attention. House Bill 376 in Alabama. While this may be a bill that was proposed with good intentions, it carries significant implications that threaten the safety and security of girls and women that are facing life-threatening situations involving human trafficking, sexual abuse, and domestic violence, particularly those from marginalized communities. In relation to our work at HICA, the Hispanic and Immigrant Center of Alabama, it presents unique challenges to the collaborative efforts to help victims find safety and justice. According to the National Coalition Against Domestic Violence, 1 in 4 women experience severe intimate partner violence, ranging from physical violence, sexual violence, strangulation, and stalking. Imagine a victim of domestic violence or human trafficking summoning immense courage and sometimes risking their own life to seek refuge and assistance. Now envision this victim as an undocumented girl or woman who has fled already a violent home in her home country, seeking safety, security, and a community in a new environment in Alabama. These women face extraordinary challenges and fears, yet they muster courage to reach out to agencies like HICA to provide support. According to the National Crime Victimization Survey, only about half of domestic violence incidents are reported to police. That number is much lower for undocumented women due to the heightened immigration enforcement risks. Additionally, victims of intimate partner violence face heightened risk of homicide when attempting to flee a violent situation. HB 376 imposes stringent requirements for victims to disclose their immigration status, creating barriers that force them to choose between seeking help and risking deportation, in addition to shattering their fragile sense of security. With the knowledge that human trafficking is happening in Alabama, we should be encouraging victims to come forward. Humanitarian visas have proven to be effective and powerful incentives for victims to not just only advocate for themselves, but to help in the process seeking justice while fully collaborating and cooperating with law enforcement. Beyond the profound repercussions of HB 376 may have undocumented women and girls fleeing violence, some may argue HB 376 also threatens civil liberties by potentially infringing upon the Fourth Amendment, contributing to racial profiling and discrimination. It also erodes much needed trust in organizations like HICA and our long-established relationships with Homeland Security, ICE, law enforcement, local and federal. These partnerships are vital in providing victims with the support and resources needed to seek justice and rebuild their lives. It is imperative to recognize the significant contributions of organizations like HICA to pursue justice. HICA remains committed to serving victims and ensuring their voices are heard, and underscores our collective dedication in collaborating with partner agencies to ensure the perpetrators are held accountable.
Go ahead and finish your thought.
I would urge you to seriously consider the harm this bill could cause.
Thank you, Anna. The next speaker is Monica Mendez.
Good morning. My name is Monica Mendez. I stand before you today to share my family story. A story that illustrates the profound impact of detainer requests on families like mine. At the age of 3, I was brought to the United States in a search of a better life and greater opportunities. Like countless others, my family believed in the American dream. We settled in Pinson, Alabama, where my father worked tirelessly to provide for us. He was law-abiding, paying taxes, never getting in trouble with authorities. However, in 2011, fear gripped our hearts with the enactment of HB 56. My father feared being torn from the only home we knew. Separated from us and sent back to a country we barely remembered. The climate of fear intensified as stories circulated in our community of people detained by ICE for trivial reasons or solely based on the color of their skin. Unable to bear the uncertainty, my father made the difficult decision to uproot our family and move to Washington State. We left behind friends and belongings, hoping for a fresh start. Yet our peace was short-lived. In 2013, my father was arrested for a minor traffic violation. A complete stop he failed to make. Not speeding, not running a red light, failure to make a complete stop at a stop sign. The officer informed him that spending the night in jail would result in his release the following morning. However, early that morning, ICE had a hold on him. After enduring approximately 6 months in the detention center, my father reluctantly signed his deportation. Due to the inhumane conditions he experienced while being detained. My father was not a criminal. He was a hardworking man, striving to provide a better life for his family. His deportation tore our family apart, leaving us shattered and unable to see him since then. Now, as HB 376 looms, I urge you to consider the devastating consequences it would have on families like mine. The bill threatens to further separate loved ones and inflict irreparable harm. I implore you to stand against HB 376 and prevent the unnecessary suffering in countless families. Please vote no on this bill. Thank you.
Thank you, Monica. That brings us to our last speaker, Jerome Dees.
Good morning, Chairman, committee members. HB 376 purports to give authority to local law enforcement to go out and arrest individuals on the basis of their suspected immigration status. Now, although the bill does say that this authority would be pursuant to federal authority, I'm curious as to exactly which authority that might be. There's no 287G model or MOU that currently exists that allows local law enforcement officers or agencies to go out and make arrests based on immigration status. And case law is clear on that distinction as well. Also want to highlight proposed section 31-13-51A, which empowers law enforcement officers acting within the scope of federal authorization to arrest any individual suspected of being an illegal alien without providing clear guidance what that constitutes, and how then law enforcement officers should then determine when is appropriate to effectuate an arrest. As you've already heard discussion today, that is likely going to lend itself to increased instances of racial profiling, and we have seen countless 1983 lawsuits around officers already not understanding how to engage in that properly. There are going to be criminal and financial consequences as well. Section 31-13-52, subsection E2, indicates that despite portions of the bill that purport permissiveness, the bill also provides that noncompliance result in criminal consequences and that agencies will lose critical funding if they do not comply. Finally, 287G is an expensive program that has largely been recognized as a flawed program, which consumes time and resources from local agencies and has been proven detrimental, importantly, detrimental to public safety due to the erosion of trust between the police and local communities. So for these reasons, as well as the reasons that you've heard articulated by the previous speakers in opposition, I also ask that you vote no on this bill. Thank you all for your time and discussion on this.
Okay, thank you. All right, we now have the bill as amended before us. We've heard the speakers. Is there any members of the committee have any questions of any of the speakers or the sponsor of the bill? Representative Bolton.
Stress that I had many occasions when I dealt with the situations you're trying to address here and over my career. And I just want to make sure that, the video from the young fellow that the Special Forces fellow talking about enforcing human trafficking laws and various other things, I understand, but I don't want to imply, which he appeared to be doing, that everybody that comes across the border illegally is either trafficking, human trafficking, or engaged in some other criminal activity outside of crossing the border. Now, we routinely, when we would find people that could not demonstrate or did not demonstrate citizenship, and it was obvious most of them were migrant farmers traveling through, going from one location to another state. We would routinely enforce that with at that time it was customs immigration naturalization, excuse me. So it's not something that's unheard of for the regular law enforcement to work with the federal people. And there's a few things that I have questions about within the content of the bill. Mainly, it's going to be the reporting burden that's placed on our jails. A lot of my small jails, especially like in Pickens County, I'll have one person on duty over there, and they don't specifically run a website. And lines 289 through 315 put a heavy burden on them to then post all this information out there. I guess basically, I don't know, for public consumption, for people just to know or something, and I just think that's too heavy of a burden that we put it on understaffed jailing facilities to go through this lengthy process of making sure that they've got all this stuff posted. That's just my outlook, both working in law enforcement and also being a representative in a district that deals with personnel shortages in their holding facilities. That's just I think that requirement to report quarterly or whatever is just too heavy of a lift for me to pull somebody off the street in a sheriff's department where I've only got 5 deputies, and then have them take time to report something that otherwise in our area may ever not be used by anybody other than the media.
Right. I think, that section, I would have done some work with a couple of sheriffs and chief of police, and their concern was that they wanted to have a way to highlight the fact of the work that was being done or the challenges that their community is facing so that the community would be aware of it.
Yeah, I agree with that. That's more political than it is
right,
reality.
because that to them that was a way of asking for highlighting that we need help.
Yeah.
That was kind of the spirit behind that and working with them, I think.
Sure, I understand that. I wouldn't be able to support that for the burden that it's going to put, that section for the burden it's going to be putting on people for reporting, because I understand that the sheriffs are elected, and that they want all that information out. However, there are other channels that they can put that out on their social media or what have you without having to burden smaller counties and other people that do not have the personnel to make sure that that's taken care of. And that's just my personal outlook, and that comes from 25 plus years of doing that job, and also having good relationships with the community across the board. And that is both people who did cross the border illegally, who are seeking to get their authorization, and also people who are actually legal immigrants. And I just want to, to make sure that a couple of things that we're following what the established law is on everything else and not being overly reactive to incidents that have happened recently.
Sure.
And I understand the need to address questions from folks when they come up, especially like the young lady in Georgia. And there was a young lady in Kansas at one time here a few years back, and there's been several other instances. I just want to make sure that that we're being balanced in our approach to address the issue and not being overly focused on one issue that took place there.
And that was why it's important that, to Representative Estes' point, that the bill, to me and to the sheriffs and chiefs of police and deputies that I talked to, that it was just helping to reinforce already existing laws on the books.
Yes, sir. And that's what.
And you know, even to the point of not profiling, you know, versus our northern versus our southern border. You know, there's only one president of a neighboring country that's threatened to use the borders as an open political, you know, a leverage. And so it has nothing to do at all. I think everybody in this state house would despise racism, but it has to do with trying to be faithful to, you know, to do our job to protect our people and enforce laws that are on the books.
I understand.
Anyway, so,
Right.
Representative Wadsworth and Representative Betzel.
I've just got a question, and I did not catch your last name, but it's for Hannah. Can I ask you a question?
Can you come up to the podium, please?
What's your last name?
Ockert.
Ockard.
Ockert.
Ms. Ockard, organization, HICA, that you're involved in, do they help immigrants apply for legal status?
So we have a citizen and immigration program as well. And if they qualify, if they have collaborated with law enforcement, if they have been a victim of a certain crime, then HICA can assist with that. And we are certified by the Department of Justice.
Okay. Do y'all ever refer, even if they've not been a victim of crime, refer them or provide them a means in order to apply for legal status?
We do not do refugee, if that's something that they have asked for, or asylum seekers. We don't handle that part. We just work with victims of crime, human trafficking, domestic violence, child sexual abuse, or sexual abuse.
Thank you.
You're welcome.
Representative Betzel, then Representative Estes.
Thank you, Mr. Chairman. I just wanted to take the brief opportunity, and if the sponsor would step back up, please. Thank you. Certainly, I understand the intent of what we're working on here, and generally speaking, I can be supportive of what we're trying to accomplish. But, you know, at the same time, honestly, I sit here and it slightly angers me, and it should everyone, that we're, as a state, put in this position where we're having to step off in a territory in which, regardless, and I'm certainly not making this a political statement, that on the federal level has failed us, regardless of race. Outside of race, our borders, constitutionally speaking, we should be a nation that is secure and we feel safe in our own homes. And regardless if that border we're speaking about is on our southern border or not, the fact and reality, that is the border we're speaking about, that we have a problem here in which individuals from around the world are coming and preying upon us. And so my statement that I make is not an issue of any, and let me stop there and say, I think your speaker you had on that recorded did you a tremendous disservice to the presentation of this bill. He showed a fundamental misunderstanding of what this bill really was. And I wish for some way you could pull it back, because he did use some language that was not in the bill that inferred certain things that, as someone who can support this bill, you know, it makes it hard to do so, because that's not the spirit and intention of this bill. But here we are, we're at a point where we're having to weigh in on this issue to do what we can to keep our own citizens safe. This is something our federal government should be doing a better job, but they're not. So with that, I just want to point out a couple things. Number one, I like to echo a few things that Representative Bolton says, because on a local application level of someone in law enforcement, this isn't a very smooth, fluid process when it comes to working with the federal government on immigration. There's untimely delays and things of that nature, which I see your bill does address. So I want to make sure that everyone in this room and anyone listening understands that when there is a request for immigration to detain somebody, a federal immigration detainer is a civil process, not a criminal. It does have some bounds and boundaries, which your bill does address. It has a 48-hour hold for allow them to do their job. But there's not always a timely response from federal immigration. These are things that are going on currently. A lot of our jails are already doing the things that are mentioned here in this bill. So I don't want to give anyone the idea that law enforcement is not doing their job. And then also too, when you talk about the IAQ, the illegal alien query that is through the federal government, and it references the support center that you're to contact, those aren't always immediate returns. So at the end of the day, for anyone who is concerned, I think the underlying factor is the Constitution of this country, regardless if you're a citizen or not, still offers you some safeguards. And when it comes to the idea of a criminal charge, law enforcement cannot hold you unreasonably beyond which time you've made your bail or bond. So for anyone who is concerned here, I think this offers an opportunity for anyone to enter into an agreement with the federal government to do some partnerships that, quite frankly, a lot of times we're already engaged with. But at that time in which that you've posted bail or bond, law enforcement cannot continue to hold you beyond that. So I think my comments towards you are sort of twofold. I see a little bit of it's not as fluid as the process should be for the application of this law. But also, too, for any of those who are concerned, there are certain safeguards that are already in place in this country. And so 2 quick points on your bill does say if a law enforcement officer has verification that a person is illegal alien. Okay, so that's a big if there. That is a safeguard in there. This is not something that, to me, is indicative of a bill that is not setting out to target, as your speaker said, and I want to make sure that's clear. And then Section G on page 6, and I'm reading straight from the bill. When authorized by federal law, a state or local law enforcement officer may arrest an individual based on individual status. That would come along with the proper paperwork from the federal side and immigration. So those are safeguards already in there. So I felt like in a degree I had to kind of defend a little bit because I think your speaker did you a tremendous disservice.
All right, Representative Estes.
Thank you, Mr. Chairman. Just a point of clarification. Ms. Okert, let me commend you for what you're doing, you and your organization. I want to make sure everyone in this room understands I'm not unsympathetic. And these women who have been victimized need to be protected. And those who have been violated need to be made whole as much as we possibly can. So thank you for providing that service. And for those who have been victimized in such a way, if we can get them on a path to citizenship, I completely support that. So let me clarify that. I'm not unsympathetic and cold-hearted to these poor women who have suffered as they have. With that said, I think it's important what Representative Bedsoe said in clarifying this, and this is not a profiling bill. I would be totally opposed to that. My colleague, Representative Morris, has made a very valid point this morning. We've had that happen in this state numerous times and for generations. I am totally opposed to profiling and would take issue with any officer who would do so. But we are at a point in this country where we are being invaded. They may not be always with weapons and with military might as we typically imagine invasion. And since the federal government has abdicated its role and has done such a poor job of enforcing existing laws and protecting its people, unfortunately, whether it's Texas or Alabama or other states along this part of the southern part of this country, we have found this dumped in our laps to where we are having to address this problem. And I don't appreciate being placed in this position either. So this is a rhetorical question because I know the public hearing portion is basically done. But I would ask those who are in opposition to this bill, if not this, how? How are we supposed to protect ourselves? How are we supposed to make sure that those who do have ill intent, and those in this room today don't have ill intent, or they would not be here today trying to do this and operate within the American legislative process to be heard. So I commend you all for coming today. My concern is with those who do have intent of inflicting harm on this country. And since the federal government won't do it, and even if we had an administration who had the courage to do it, which we currently do not, if we had an administration who would do it, we don't have the manpower to do it. So entering these type of agreements are critical to make sure that we can address this problem to the best of our ability. But let me stress that I want to make certain it is done within the law, without profiling. And I do agree with Representative Bedsoe, too. I want to thank the gentleman in your video for his service to this country. I think his intentions are good, and we've all been guilty, including me, of poorly choosing words. So I would like to think that's what he did this morning in that video was maybe speaking off the cuff as he did, choosing a poor word or two. But that is not my intention in supporting this bill at all, as targeting anyone. My intention is I love this country, and we're losing this country. And someone, whether it's the Alabama legislature or who should be the United States government, someone has to finally have the courage to stand up and say enough is enough. Let's protect those innocent victims who have been victimized to the best of our ability, but find a way to preserve the borders of this country, whether it's the Canadian border or the Mexican border. It's just unfortunate right now it is the southern border which is more easily accessible to those who are flooding into this country. So I know that your intent, and I know what they are, and I'm appreciative of that. I just hope these partnerships will be operated and used as they're intended to be done to protect this country, to keep an extremely bad situation from getting even worse. Thank you, Mr. Chairman.
Okay. All right. Representative Fiddler.
I was checking with our local law enforcement, and on page 8, we keep talking about 48 hours, but they were telling me it was 72. So is that a federal, the inmate shall be held no longer than 48 hours pursuant to an immigration detainer on line 207? Or
Right. No, I do not have the answer whether that's state or federal. I don't know the answer to that question.
want to make sure that we're not, you know, taking that down a notch when maybe it was 72. I'm not sure if anybody else here on the committee.
Let's do this. As is customary, being a public hearing today, we will not be voting on this bill. Get with the sponsor, and y'all work that out before the bill comes back up. Any other questions by any other members of the committee? Not seeing none. We will not be voting on this bill today. I thank everybody for coming and the members' input and everything. So with that, I will entertain a motion to adjourn. A motion to adjourn by Representative Pettis. All in favor indicate by saying aye. Aye. All right, we are adjourned. Thank you. Thanks for coming, folks.